Hello, my name's Liz Ward and I'm an expert intellectual property solicitor with about 30 years worth of experience. I'm going to touch on today the costs of litigation because it's a question that we are quite often asked. I mean, a lot of litigation, a lot of contentious and dispute work doesn't go all the way to trial. In fact, most of it settles well before trial, and if you've got a good case, that should certainly happen. However, from time to time, we're asked, understandably, to budget for what it costs to take a matter to trial. So I'm going to try and explain in the next minute or so exactly what factors we need to take into consideration and what makes something more expensive or less expensive as a piece of litigation. So let's just talk overarching figures now. If you take a case through the IPEC Court with us, you're looking at costs of, if it goes all the way to trial and a 2-day hearing, probably around £220,000, something rather like that. Now that can vary a great deal, and the reason that it will vary is because it depends very much on the kind of case that's pleaded, how much evidence there is, whether or not there's an expert involved, and also the level of disclosure that we have to do. The other thing that massively affects costs is the seniority of the barrister that you instruct. And clearly, if you have somebody who's a KC, who's very, very experienced, they're going to charge, double probably what a junior solicitor or barrister will cost at that stage. So that's something to bear in mind. There are ways to keep costs down. And the way to keep costs down is obviously to instruct somebody who's slightly more junior when it comes to drafting pleadings and doing the court work. We try and balance the costs by not having senior fee earners on every detail of it. So we have a lot of juniors who are very good at some of the heavy lifting. That keeps the costs within control. Limiting your pleadings too. So not having a kitchen sink claim where you've got lots and lots of different things all pleaded in the same case. And last but not least, one of the other key things is expert witnesses and how many witnesses you have, because you're limited really in terms of time for the IPEC courts as to you're only 2 days in trial. So you really need to focus on which are your witnesses, your key witnesses, and whether or not you need any experts. When it comes to High Court costs, it's completely different. And your cost in a High Court matter can easily exceed £500,000, £600,000, and that's without instructing a KC. So what are you expecting to be on the hook for if you go for High Court action? Well, a High Court matter is not restricted in terms of the damages that you recover. It's not restricted in terms of the costs that you can recover from the other side. But what you need to do is to focus on what your best case is in a High Court matter. So again, you're not wasting money on pleading things that don't stand a chance of success. It's all about filtering all that out before you even get to the first stages of court. Or if you have got claims like that within your pleadings, then looking at removing them or looking at narrowing them down so that the scope of them is not quite so broad. Things you can do too is dispense with a witness if you don't think, an expert witness, perhaps if you don't think that an expert's required, but you can easily spend tens of thousands of pounds on experts. And again, narrowing disclosure. Disclosure these days is quite straightforward if you get it right. And this is where a lot of people make some massive mistakes, particularly with electronic disclosure. Electronic disclosure can be your greatest tool. It can also be your biggest cost exposure because people don't necessarily know how to precipitate out precisely the documents that they want. And that's absolutely key to making sure that your case is really well managed. So get a well-managed case, get a good QC, get an expert involved, talk about costs up front, make sure you've got your budget, and bear in mind, even if you win, you might not get all your costs back. In fact, in some cases, you might not get a penny back, even if you've won. And let me tell you, that's a bit of a shocker and a stinker when it happens, but it does happen. Costs are discretionary. Judges don't have to award them to you, even if you're the winner. I hope that's been useful. Thanks for listening. Bye for now.